Thank you. If it please the court, my name is James Weekly. I represent the cross-appellees, defendants during the trial, the City of Fresno, and Officers Daniel Estachio and Greg Catton. This case involves an appeal, cross-appeal, and we're both a cross-appellant and a cross-appellee. In order for the court to understand how the jury came to its conclusion in the case, I think it's important to set up the scene and help the court understand how the scene was at the time of this incident. So I'd like to take a moment to talk about the apartment complex, driveway, parking area, so that the court understands all the various scenarios that come into play here. The Stony Brook apartment complex in Fresno, to get into the complex, you have to drive north through a gate. To get to where this incident took place, you have to then turn east and travel down a driveway that is on the north side of the driveway, and the south side of the driveway is lined with apartment buildings. Along the driveway is also parking stalls on the north side and south side. Like I said, to get into the complex, you have to go through a gate. At the time of this incident, Fresno police officers were investigating a gang-related issue just outside the gate. Officers Estachio and Catton were providing cover for the other officers that were dealing with the gang members. Mr. Willis came to their attention when they heard a vehicle traveling at a high rate of speed and then heard tire squeals coming towards them. He stopped for a moment, then he turned right to head into the apartment complex. The officers heard the vehicle strike what they thought was the gate. It turns out what he actually struck was a yellow pole that was protecting the keypad to get into the gate. He then drove into the apartment complex, turned right, and at a high rate of speed, they could hear his vehicle accelerating through the parking lot late at night, and they could hear noises like if the vehicle was hitting something. Since the gang-related issue was winding up, Officers Estachio and Catton decided they should go and investigate what they thought was a possible DUI and hit and run. About the same time, their Sergeant Reyes, told them to go investigate it. So they walked into the apartment complex, turned right, started heading east towards Mr. Willis's direction of travel. They thought they were just here to investigate just conduct a routine investigation. As they approached where they saw Mr. Willis at the time, Mr. Willis had pulled into his parking stall next to his apartment. His girlfriend had jumped out of the car to run into the apartment to throw up. They had been out drinking. In fact, they were kicked out of a bar. They were so drunk. And she was running into the apartment because she was sick. Mr. Willis was at the back of his vehicle with his trunk open, with his back towards the officers when they approached him. They approached him and said to Mr. Willis, "We're here to talk to you," or some words to that effect. Willis then turned, and what the officers saw was a very large 38 caliber large frame handgun in a holster with a snap on the holster. Willis was holding to his chest with his left hand, with the handle of the gun coming up. The officers saw that gun. The gun is very similar to what law enforcement used to use many, many years ago when they used revolvers. It was a large 38 caliber revolver. When the officers saw the gun, they started to pull their service weapons and they yelled for Willis to drop the gun. Instead, Mr. Willis pulled the gun, which unsnapped the holster, pulled the gun out, and brought it around towards the officers. Officer Catton was towards Mr. Willis's right, holding a flashlight on Mr. Willis. Officer Estachio was more towards the left. Officer Estachio described Willis as pulling the gun around, going past his face in the direction of Catton, when Officer Estachio fired the first round, striking Willis somewhere in the right or left side. Officer Catton then fired a round, or Willis, we're not sure which. Officer Catton's round hit Willis's forearm through the muscle, not the bone, which after that caused Willis to be unable to get a full trigger pull. And what he did was what's called a short stroke. And that is important because that explains how the empty chamber of the revolver got two positions over from the firing pin. With a short stroke, the chamber rotates, locks into place, but without being able to get a full stroke, the firing pin doesn't come down. And we had a gun expert, a firearms expert, that was able to explain all this and demonstrate it to the jury. Willis fired a round that went westerly, striking the car that Officer Serta was pulling into the apartment complex. The bullet left an indentation in the car that Officer Serta said was not there at the beginning of his shift. So we know that was caused by Mr. Willis, who was the only one shooting in that direction. Plus, the type of ammunition that Mr. Willis had was very cheap, slow-moving, soft-lead type of ammunition that just caused a dent instead of penetrating the sheet metal. The officers were using jacketed bullets. If their bullet had been fired in that direction, it would have penetrated the sheet metal. Again, that was undisputed by our expert testimony. So we know that that bullet indentation was caused by Mr. Willis when he fired the one round. Mr. Willis then retreated, now traveling north through vehicles. The officers then separated and traveled north through vehicles. Officer Stachio to the east, Officer Catton to the west. They're using the vehicles for cover because they're believing that Mr. Willis is a threat. Mr. Willis is seen on the side of a van. He's seen through the windshield of the van, and that's when the officers re-engage Mr. Willis. Again, so we know this because some of the strikes were caused by bullets that were with an irregular trajectory. The officers then lose sight of Mr. Willis again. Believing that Mr. Willis is heading north to go into the apartment complex and become a threat to citizens and other people there, the officers proceeded north through the vehicles themselves. When they got to the north end of the vehicles, the officers saw Mr. Willis kneeling with his gun pointed in the direction towards Officer Canton. Officer Stachio described seeing a silhouette, which he believed Officer Canton, with Willis pointing in that direction. Officer Canton described Willis pointing the gun in his direction. So both officers then re-engaged. Mr. Willis wouldn't go down. He was continuing to point the gun, and the officers believed firing the gun at or towards Officer Catton. Officer Catton briefly stepped to the front of the vehicle thinking he could get a better line of trajectory and felt something hit his left leg. He then retreated back behind the vehicle to check and found there was a bullet hole in his pants, but he had fortunately not been hit. Officer Stachio continued to fire until Mr. Willis went down. Now, we know that Mr. Willis had a gun out, not only because of the shot earlier to Officer Serta's vehicle, but also the holster was found some 10 feet or further away from where the gun was found after the shooting. And the holster had a snap on it so that gun wouldn't just drop out of the holster by accident. That was demonstrated to the jury. Mr. Willis went down. Officer Catton then came around to join Officer Stachio at the east end of the vehicles to provide cover, while Officer Stachio then was able to retreat and call for assistance. It was during this time other officers were arriving. They were outside the apartment complex. They heard the gunshots. Officer Serta was the first to arrive, staying right behind Officer Catton. Officer Jacobo and Sergeant Reyes arrived shortly after that. Officer Serta describes coming up to Catton. Officer Serta briefly looks around the vehicle. He could see Mr. Willis's legs moving and twitching. He then retreats back behind the vehicle. He tells Officer Catton, stay behind the wheel, believing that Mr. Willis is still a threat and could shoot under the vehicle. Officer Catton then starts yelling, and Officer Serta hears him yelling some words to the effect of drop the gun, don't go for the gun, something to that effect. Then Officer Catton fires one or two more rounds. In a nutshell, that's the case. Mr. Willis then goes to the ground again. Officers Serta and Jacobo go up and secure Mr. Willis. They handcuff him, search him, and then Mr. Willis is finally no longer a threat. Based upon this, it's our belief that what the jury found that since Officer Stachio was not negligent at all, there's no Fourth Amendment violation that Officer Stachio committed. And as the district court pointed out, because the officer's conduct was virtually indistinguishable through these first three phases, then by that finding, the jury had to find that Mr. Willis was 100% at fault for everything that happened through the first three phases. It's only the fourth phase, when Officer Catton was the only person to see Mr. Willis and fired the last round or two, that the jury's finding could be based on. And of course, the jury's finding was for a Fourth Amendment violation and awarded nominal damages of $1, and for negligence, but that Mr. Willis was 80% at fault. And that's significant because what we believe the jury then found to get that finding was that Mr. Willis had to be doing something to be 80% at fault. He had to be doing something.
Well, it could have been, the jury could have assessed his fault for looking at the incident as a whole. The jury wasn't required to make the 80-20 finding just focused on that last couple of seconds.
Mr. Willis was 100% at fault for everything that happened before that.
No, just hang on a second, because it's part of the posture we're in is your fault, it seems to me, because we don't have special interrogatories, right?
Well, I'd like to get to that in a moment too, but right, we don't have special interrogatories.
But my point is that you don't have any basis to stand here and say that what the jury did was assess 100% fault for the first three phases and then look only at what you're calling the fourth phase and assess its 80-20 percent allocation as to that. I think, if anything, the contrary is true, that probably the 80-20 breakdown came from the jury looking at the situation as a whole and saying he was at fault for most of it. And yes, the officer used excessive force at that last second, but
unfortunately, we're speculating to
right.
do that.
And that unfortunately dooms your argument, it seems to me, on this point.
To get to the other points then, and that would go to argue that there was no substantial evidence to support a jury's finding of a Fourth Amendment violation or
there were
negligence.
Two versions of the events that the jury could potentially have found here. One in which Willis was reaching for the gun at the moment he was shot, and the other in which he wasn't. It seems to me the jury, if it had bought the first version of the one you wanted them to accept, they wouldn't have found any liability for Officer Catton.
If the jury believed the plaintiff's theory of the case, and that is that Willis was doing nothing but lying on the ground when he was shot, then that would not be consistent with the jury finding.
The jury doesn't have to believe 100% of either story. It can mix and match. And in this case, if they said if Willis was doing all the things you said he did, but at the end he was lying and it wasn't reaching for the gun, and your client shot him anyway, that seems to me the most plausible way to reconcile the jury's determination. And if that's the case, what are we supposed to do about that?
If that was the jury's determination, then the jury would have found that Officer Catton was at least reckless, yet they found no punitive damages.
Maybe they just thought he panicked. That he was nervous. I mean, why? I don't think you have to find recklessness. I mean, I feel some sympathy for Officer Catton. You know, he's in a tense, volatile situation, but maybe the jury just said he overreacted.
Well, then that would take us to the qualified immunity argument, that the court would have to find that no reasonable officer would have done what Officer Catton did. And again, there's two problems with that. One is, well, actually three problems with that. One is the jury's finding of no maliciousness, oppressiveness, or recklessness. Two is the finding of comparative fault, which we argue is only in that last phase. But maybe more importantly was this court's finding some years ago, I think in 2013, when we were here arguing the motion for summary judgment. And the court reversed the granting of the motion for summary judgment on the constitutional claims. And what this court said was that with the exception of the first shots, that no reasonable jury could find that the officer's conduct was for anything other than utilized for the legitimate law enforcement objective. In other words, this court found that after the first shots, everything that Officers Catton and Estachio did was for a legitimate law enforcement objective.
Now, the jury concluded something different.
Well, it wouldn't be consistent then, and qualified immunity is not for the jury to decide, it's for the court.
Well, let me ask you this. Did you argue, and I don't, maybe it's in your brief, but I didn't see it. Have you argued either the district court or here that the law of the case is such that that the only thing before the jury was the first shots?
Yes, we did. And
is that in your briefs for an appeal?
I don't think it's in the briefs. It was during the trial, during the arguments in the trial and the motions in limine.
So what are we supposed to do about it?
Well, the case law is there. I mean, this court decided.
You didn't say anything to us about it, so we're supposed to go back and decide for ourselves what arguments you might have made?
I take that back. It's on page 40 of our brief. So I only have 2 minutes left. I'd like to save time for rebuttal unless there's some further questions, and I would submit the attorney's fees and the evidentiary issues to be submitted on our briefs.
You said it was page 40 of your brief?
Page 40 of our initial brief, at the bottom where we talk about the Willis versus City of Fresno 9th Circuit 2013 case.
Okay.
But you don't anywhere use the words law of the case or anything like that. You just cite the Willis case.
Well, actually, the first sentence says, pursuant to the law of the case doctrine, Officer Catton's final shot was utilized for a legitimate law enforcement objective. Any further questions, Your Honor? Thank you.
Good morning, Your Honors. May it please the Court, Bo Burbage for the plaintiffs in this case. Let me just make a clarification on the get-go on the point that counsel just made. regarding the court's prior memorandum decision on the motion for summary judgment. The portion of that memorandum decision he's talking about relates to the 14th Amendment, and the court held that the jury could find that the officers acted with a purpose to harm as to the first shots, but as to any subsequent shots, the jury could not find there was a purpose to harm. It's apples and oranges with the Fourth Amendment claim that we're talking about here.
Right, so, I hope you're not going to give us a 10-minute recitation of the facts. Let me just jump in and ask you. So given our decision in Chowdhury, what exactly needs to happen now in your view?
Your Honor, based on the decision in Chowdhury, which was a issue that we briefed fairly heavily prior to trial, I think every district court in California had accepted these pre-death pain and suffering damages in 1983 cases. And Chowdhury came out in line with our briefing. I think a new trial is warranted. You had in Chowdhury circumstance where a young man was shot by police and died on the scene. He was awarded $1 million in pre-death pain and suffering for that.
Right, but so you're talking about a retrial in which I guess all of the issues that this first jury settled are, assuming that we were to affirm everything else, all of that would remain in place, but you would just have a new trial. I'm trying to imagine what that new trial would look like, I guess.
Your Honor, we were trying to imagine it yesterday, and the conclusion came to it is that we have several issues that we want to be retried. We would be happy to retry the whole case without alcohol and marijuana evidence, which we found to be completely improper and.
Before you get to the other issue, and you're talking about starting from scratch. That's what you want to do?
Correct, Your Honor.
Okay.
With
regard to the. I'm not conceding your alcohol and drug evidence. That's another issue. You just want to. Based on the Chowdhury decision, you're saying we should go back to square one, or we should go back to what?
We would like to just try the damages portion of that aspect.
Yeah, you don't get to try the whole. Assuming we were to affirm everything else, the liability has been established, and it's only going to be for that last shot, and you just want to put on evidence, I guess, for I don't know how many seconds of life we're talking about.
Correct, Your Honor.
Right, but that's what the new trial would consist of?
If that was all the new trial were to, if it was only on that point, that's all the new trial would consist of.
Well, no, I'm asking you, what do you want us to do?
Exactly what you just said.
Okay, that's all you want.
To be able to present evidence in that regard.
And then you think the entire attorney's fee award has to be vacated, I assume, because
we would like it to be revised if there's the attorney's fees award was adjusted downward. That's really what we are.
But it was adjusted downward in part because you basically, if for some reason you got $1 million on this pre-death pain and suffering claim, I'm not saying that that's what would be likely here, but if you did, it seems to me the rationale for the judge's attorney's fees ruling would be probably completely different, wouldn't it?
Correct, Your Honor, and so we would want a revisement of those attorney's fees.
Right, okay, so what I guess I'm trying to figure out is what, of the arguments that you've raised with respect to the attorney's fees award, which of those do we actually need to address now, given that, in fact, there might be an entirely new attorney's fees decision that would be rendered post this new trial?
I would say if these decisions are made regarding a new trial and the points we've raised, that this court should not bother to evaluate the attorney's fees, because you're right, they would be changed. They would be modified based on the outcome of whatever issues were being retried.
So you don't think we need to address the reduction in the hourly rate even?
I think that could be re-raised at that time again. Our main concern, Your Honor, was over the adjustment, the downward adjustment, the 35% reduction based on the lack of success, which kind of dovetails with the rest of our arguments. That we were prejudiced to the trial for various reasons, not being able to seek damages, having this alcohol and drug evidence admitted, that all contributed to what the court perceived as a lack of success.
Well, you want to talk about the evidence. Why is it the drug and alcohol evidence wasn't relevant?
It wasn't relevant because under Graham versus, under the Graham versus Connor case, the Supreme Court made it very clear that we can only view what a reasonable officer of the scene saw.
And that what they viewed is somebody behaving in an erratic manner that could be well explained by the fact of drug and alcohol abuse.
And that's true, Your Honor, in
so why isn't it relevant?
Case, but if you look at more recent case law under Glenn versus Washington County, Hayes versus San Diego. The court excluded that evidence, even though it would be very helpful to the officers to explain conduct. In the Hayes case, the officers confronted a man who supposedly had a knife. He had been drinking heavily. He had previously tried to stab himself. When they told him to raise up his arms, he raises up his arms with the knife in hand, and they shoot him. The court excluded any evidence he had previously stabbed himself, that he had been drinking. That could explain his erratic behavior, and that would support the officers.
Hang on a second.
Excluded.
Tell me if this distinction is wrong, because this is how I had sorted out our cases, and I agree with you. They do seem to be in some tension. But the way I sorted them out was this, and then you tell me if I'm wrong. In those other cases, what the suspect or the plaintiff, whatever, the decedent, what that person did wasn't in dispute. So in other words, what the officers were objectively seeing in terms of that person's conduct wasn't in dispute. Whereas here, especially with regard to the first set of shots, it very much was. Your position was that your client never reached for the gun, drew it, and pointed at the officers. And it seems to me it is quite relevant whether he was as intoxicated as he was to figuring out whether your version of those events was true or whether the officer's version of events was true.
Well, respectfully, Your Honor, I think that there were issues in dispute in the Hayes case. Obviously, the police officers weren't accepting the plaintiff's argument that the man was just trying to surrender and raising his hand. They were arguing that he was raising his hand to attack them. On the other hand, the plaintiff was arguing that his intent was to do what they
I'm
said and
talking about
surrender.
the subjective motivation of the defendant, or again, the suspect, whatever we're going to call the person. I'm talking about objective conduct that is visible to the officers. And in your case, that's very much in dispute, right? Especially with respect to the first set of shots.
Well, and here we have a case where the entire bulk of the evidence is coming from the officers themselves. What's not in dispute?
Right, but listen, you're going to tell us that it would not, if I'm sitting there in the jury box and one version of events is the officer saying, we yelled at the guy, drop the weapon, and, inexplicably the guy drew it and pointed it at us. That's right. A jury would be quite skeptical of that. But if they knew that, in fact, he was highly intoxicated, that might make it more plausible that the officer's version of the events is true. So I don't see how you can say it has no relevance to that.
What we have is a very rapid situation where the police officers are walking up on Mr. Willis getting out of his car, removing something from his trunk. They say he's not staggering, not stumbling, not acting intoxicated in any way. There's no observation of that. They see him doing nothing threatening, nothing normal, and he turns around when they
don't see him doing nothing threatening. By their story, he's pulled a gun and is starting to point at them.
I'm getting there, Your Honor, because they shine a flashlight on him, he turns around, and they immediately pull a gun on him. Thereafter, it's split seconds before he's down on the ground, having been shot several times. I don't think that the fact that he had consumed alcohol is going to be relevant to any determination. There really was no portrait they were painting of any kind of erratic behavior.
They said that they had him in their sights with the flashlight, guns drawn, and said, drop the weapon. Most sober people are not going to pull a gun and point it at the officers in that situation.
Most drunk people aren't either, I would submit to the court.
No, they are if they don't hear or process the commands that are being given to them. It makes it more likely that they would act in that irrational manner if their judgment has been impaired heavily by alcohol, as your client's was. I'm not saying that it conclusively proves anything. I'm just saying it's definitely relevant to sorting out whose version of events was correct. And that wasn't true, I think, in the cases that you're relying on.
I would think in Hayes we were looking at intent. Same in Boyd. I don't think there was any dispute that there was some erratic behavior, but they had been presenting a defense of a suicide by cop. That was their entire defense. So they were allowed to present evidence that he had previously tried to commit suicide by cop, that he was on drugs, to show that erratic behavior. But here we have really
got erratic behavior because it was insane to pull a gun on officers who are pointing their weapons at you and telling you drop the weapon. That makes no sense.
And of course, there's a dispute that as to what the version of events that the officers were giving, because after the event,
that's why the evidence is relevant.
Let's talk about marijuana then, Your Honor, because
can I go back a second though? Yeah. You keep making the point they had no reason to believe he was intoxicated, but they were there to investigate a DWI. I mean, the fact that he was driving erratically, hits the gate on the way in, squealing his tires, they went up with the mindset that we're probably dealing with a drunk driver.
I think it was speculative that they were dealing with a drunk driver. They
Well,
heard a car.
it may be speculative, but it's reasonable speculation that if you're squealing the tires, you hit the gate on the way in at 2:00 in the morning, it's not a stretch to say that guy may be drunk.
And of course, our position is they never put two and two together. They heard something.
Didn't they testify they went to were investigating a DWI?
They were looking into the apartment complex, and they didn't say, that's the car, we're going to go after that car. They heard something, they went to check it out, and they just happened to see Stephen Willis getting out of his car. But the possible DWI doesn't mean that there's an issue of, they don't have any actual evidence. They're just going on a hunch. This might be a DWI. It doesn't mean he's going to get out of the car and start shooting at the officers.
Oh, I don't think it's not being offered as something that entered into their calculation. It's being offered as something that explains why somebody behaved in a way that otherwise you wouldn't expect someone to behave. And the question that Judge Watford posed, I think, is still sitting there. He did something we wouldn't anticipate. Now, you say, well, you wouldn't expect drunks to do that either, but drunks are more likely to behave in an irrational way than somebody that's sober. And if this helps tell the jury why he did something you wouldn't expect somebody to do, I can't see how it's not relevant.
I think that there's a huge spillover of this alcohol evidence where it permeates every portion of the case. So the judge on her post-trial rulings said that counsel could have explained that this isn't probative to what the officers were doing, but it's probative to what he was doing. Well, the jury's not going to be able to understand it that way, and it's really going to affect every aspect of the case from liability to damages. So I think it has to be very probative to explain his behavior to be able to get in there. Remember, there is a balancing test of probative value versus prejudicial effect that the evidence is going to have, and this was very, very prejudicial evidence. Even more prejudicial was this marijuana evidence, and I've never seen a case or heard of anyone pulling a gun out and shooting officers because he was high on marijuana. And we cited the Hernandez case in our briefs because it's very well reasoned. Without any expert evidence showing a causal connection between marijuana use and some action, it's just speculative. It's just prejudicial. It's damaging, and it had nothing to do with this case. I mean, the defendant's own expert said that Mr. Willis, he couldn't tell whether he had smoked marijuana within the 72 hours before his death. But then that became a central theme of the defense's case, where they...
Well, it was more the alcohol. I mean, I agree that in closing, the defense lawyer did make a reference to the marijuana use. And you may be right that the marijuana evidence shouldn't have come in, but I can't, for the very reason you just described, I can't imagine that it affected the jury's analysis of the case.
I think it would have affected the jury's analysis of the case in terms of assigning more blame to Stephen Willis. He was a druggie. He was a bad guy. There's a lot of prejudice around that.
He was heavily at fault for getting shot, if you believe the officer's version of what happened initially. You can't deny that.
I don't think that 80% negligence can be found by the jury without that evidence of alcohol and marijuana.
I mean, their version is that the other officer's not liable at all. So it's when you come to the last shot, that's finally when somebody other than your client is responsible for the situation. If he hasn't acted erratically in the first place, none of this happens. So if the jury is thinking that way, I don't see how 80% is implausible. It's not at all a surprise to me.
When you have, especially in communities outside of San Francisco, someone who uses drugs or uses marijuana, that can permeate the whole case from damages all the way through his liability. And I think that certainly had an effect on it. And it was certainly, I mean, if they hadn't used it so much and so effectively in their opening, in their evidence, in their closing argument, then it wouldn't be an issue. But I mean, the closing argument said Stephen Willis wouldn't have done what he did if it wasn't for the marijuana and alcohol.
No, that is not what he said. He said, if not for him being drunk
and the marijuana.
Yeah, but that's what I'm saying. It was secondary to the alcohol use, which, again, the jury had no basis for concluding that the marijuana use had any effect on what your client did, but it did have a basis for making that assessment on given how drunk he was. I think he was, I can't remember what the level was, but it was well up there. Right?
Well, and there were arguments made as to fermentation of the blood, and that was a heavily disputed issue, of course. But the jury, let's say the marijuana was completely irrelevant to their determination of what Stephen Willis was doing at the time. Well, then it's just purely prejudicial. It should have been kept out.
Can I ask one question? The city and the officers spent about 10 pages of their brief arguing that Darcy's expert opinion was not properly admitted. And I don't see you responding to that argument.
As to Darcy's expert opinion?
Yeah.
But because Darcy really was not a incredibly helpful expert to us, I think the defense used him on closing argument and referred to him as their expert. So it wasn't a incredibly important point, and I'm not familiar with it being pertinent to any of their legal claims here on appeal. With no further questions, Your Honor, we'll submit.
Thank you. Rebuttal?
Thank you, Your Honor. Very briefly, the marijuana issue is one that we didn't raise, although the court ruling in limine was broad enough that would possibly allow that evidence to come in. I didn't raise it. I didn't want to create an appellate issue. It was plaintiff's counsel that first raised it with his own expert, asking his own expert about the marijuana in Willis's system. Only after that did we even mention marijuana. In addition, plaintiff's counsel stipulated photographs coming into evidence. They were joint exhibits, and those photographs were the inside of Willis's apartment that showed marijuana plants, a grow system, a bong. Now I'm going to address the pain and suffering, if I may. Remember, the first 13 shots were a result of reasonable use of force. Only the last shot was did the jury find any liability. It would be pure speculation to think that Willis was even capable of feeling pain and suffering under the plaintiff's theory of the case that he was down, possibly dead already. Dr. DeMaio, the pathologist, testified that given Willis's blood alcohol level, it's unlikely he would have felt any pain.
All arguments you get to make to the jury. I mean, we're not in a position to sort that out, right?
And I have a comment about the attorney's fees, if I could just have one more minute, but otherwise I'll submit it.
What?
The plaintiff did not get anything more than a partial or limited success. And again, we covered this in our brief, but given...
But no, the only issue is how much, if any, should we address any of the attorney's fees arguments, given that the entire basis for the decision could change in light of this new trial that's going to happen? It doesn't sound like you have an argument to resist the new trial.
Well, if there is a new trial, and I think that the jury's verdict was based on speculation to begin with, but if there's a new trial, I would request this court to seriously consider the qualified immunity for Officer Catton for all the reasons we set out in our brief. And at a minimum, we were handicapped because after our Rule 50A motion, the court wouldn't allow us to submit questions to the jury, which it's really a disadvantage for a defendant that we don't know what the court thinks are triable issues until we argue the Rule 50A motion. So we request the court help us. If there's questions you have, what are they? And at one point in time, the court did that. The court drafted her own 3 questions, and then the next day she changed her mind.
And at what point did you point me to something in the record that reflects proper questions to be posed to the jury that were submitted to the court, and when were they submitted?
Our questions were submitted after the court ruled on our Rule 50A motion, that the court felt there were issues that had to go to the jury. We did not think there were. We did not see. But
lots of times lawyers go in with confidence they're going to get result X, and the court says not X, and you're in the midst of the proceeding. I mean, as I try to go through the history of this, and I can sense the court's frustration, it's being asked to improvise things on the fly, and it takes a run at it, but doesn't work. I'm not sure why it is that's the court's fault. If you elected not to submit proper interrogatories, proper special verdict form in advance, whose problem is that?
Well, Your Honor, you can imagine in a case like this that's factually complex as this is, if we were to submit questions in advance of the trial, we would submit 100 questions. It would be futile. It'd be a waste of time because we don't know what the court's thinking.
Well, that's the same way. You can say the same thing about jury instructions. So why should you ever propose jury instructions? Because you're going to win the Rule 50 motion.
Well, these jury instructions are for a whole different purpose. We all know it's a use of force case. So that's an easy instruction to submit. Thank you, Your Honor.
Thank you. Thank both counsel for your arguments. The case just argued is submitted.